Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Gisela K. This is Grizzly True Crime. Today we're going to be looking at the Delphi case. There's been a couple of updates in the last few days. Of course, we've been very busy covering the trial. We are still covering the trial. This stream will lead you to that one, which is the trial of Gisela K. So, I've gathered some things here for you and we can go over it together. Welcome to all my moderators. Thank you for everything you do. Welcome to all my patrons, members, OGs, and all the subscribers that will subscribe today. Even all the lurkers. Hello, I hope you come out and say hello to us. Happy Friday to everyone. I believe tomorrow's Veterans Day in the USA, but I think many of you are off today. Are you not? Are you working or are you off? I hope that you have a day off for yourself today and that you will have a nice weekend. So, we've got a couple of documents to power through. 1, 2, 3, 4, 5, 6, 7. 7 of them with vital information. So I'll make it as interesting as I can for you. It is very interesting. Oh my word. What's going on in Delphi? If you don't know anything about this case, I hope that you will check out the description box either for a case background or the playlist, which has a lot of videos on there for you, including a case file where there's all the chronological press conferences and you know, the media interviews and all this kind of stuff before, and a few including once Richard Allen was arrested. Of course, without a fair trial for the suspect Richard Allen, there can be no justice for Libby and Abby. And of course, if the truth is also not out, there's also no justice without the truth. So, Lenora, welcome. Hadn't answered your last email yet, but there you go. Now you're going to have badges next to your name. Welcome to YouTube membership. Coastal Butterfly, oh my word. You have been a member for 23 months? Happy Grizzlyversary and thank you for your support. You say Happy Veterans Day today. Tomorrow's Veterans Day, I believe, but I think today is the holiday, right? So I hope you guys are having a good day. Okay. So, okay. Now let's get first, I just want to do something very quickly and then we're going to dive into this. I just want to make sure that this stream will redirect you to the next one, okay? So that you're all set up for your Friday with me. I hope that you will be there with us for the next one as well, because, whoa, it's going to be a snarky time. It's a snarky Friday. I can feel it. So, Jeannie Gayagoy, did I say it right? You said, so thankful for the veterans who fought for our freedom and a day off to catch Gisela live. Thank you so much, Jeannie. Really appreciate it. Okay, so this one, I've lined them all up for you. This one is a one-page document. Let's make sure we zoom in a little bit. This is in the Indiana Supreme Court. So as you know, Judge Gull in this Delphi case, right, dismissed Richard Allen's attorneys and then she assigned new attorneys to Richard Allen. And there's been a whole battle about that. But now the Supreme Court is involved and she is in big trouble because the Supreme Court and the board are saying, this isn't right. So it's not just us in the public here saying, well, something stinks in Delphi, something isn't right. Now the Supreme Court's involved and they're saying, this is not right. This Country Girls Live says, happy birthday to my brother Michael. I hope your brother Michael is a Grizzly too, and happy birthday to him. Yes, and thank you for supporting the channel for 19 months, this Country Girls Live. Now, they say here, State of Indiana, ex-rel Richard Allen, relator versus Carroll Circuit Court respondents. Okay, this is the Supreme Court document. Order. Proposed amicus curiae. Did I say that right? Are there any lawyers' ears hurting? I hope not. The Indiana Public Defender Council, okay, is composed of public defenders and other court-appointed attorneys regularly appointed to represent indigent defendants. Proposed amicus is substantively aligned with the relator who filed a petition for writ of mandamus on November 6, 2023. Proposed amicus filed a motion to appear as amicus curiae according to Appellate Rule 41 and tendered a brief. Being duly advised, the IPDC's motion to appear as amicus curiae is granted and the clerk is directed to file this amicus curiae brief as of the date of this order. Respondents may include any response to this. And so the point is, the Supreme Court is now involved. Just give me one moment. I think I'm looking a little pink. I'm going to put my salt lamp off. Hold on. Should be a little better. Okay. So that's the first one. Then this is this amicus curiae in support of the relator's petition for writ of mandamus. I've highlighted some portions for you so we can go through this. Okay. I hope you've been following along as we've been unfolding, everything that's going on here. So they say the Indiana Public Defenders Council, the IPDC's mission is to improve legal representation provided at public expense in Indiana state courts. This mission is fulfilled in part by providing research, training, and consultation on strategy and tactics. The IPDC is also mandated to assist in the coordination of the duties of the attorneys engaged in the defense of indigents at public expense and maintain liaison contact with study commissions, organizations, and agencies of all branches of local, state, and federal government that will benefit criminal defense as part of the fair administration of justice in Indiana. They're saying the same thing. I can't believe that now the Supreme Court is involved and also the Indiana Public Defenders Council. And the judge is still kicking her heels in and delaying things, which is pretty scary as well. So, they say, let's just go to where I was here. Benefit the criminal defense, in Indiana Code. The IPDC is well positioned to address the importance of independence of the defense function, a topic at the core of the work it does. IPDC's interests are aligned with the relator, Richard Allen. Whoa. In raising concerns about the removal of his court-appointed counsel. However, this brief intentionally focuses narrowly on independence concerns. The council is committed to supporting appointed counsel, whomever that may be, as this case continues. Summary of the argument. I know this is very document heavy, this episode, but I'm sure you will find it interesting as we go along. I put the longest one first so that we can power through this one. Indiana has long been a leader in providing appointed counsel and in recent decades has made strides to preserve counsel's independence from the judges before whom they appear. The removal of appointed counsel for broad or vague reasons undermines the independence of the defense function and extinguishes a long-standing rapport with the client who must now languish in prison for an additional 9 months. Whoa, okay, so moreover, after removal of counsel, replacement counsel should have amicus brief of the Indiana Public Defender Council. Yes, so Christie is just confirming not the US Supreme Court, the Indiana Supreme Court. Indiana State Supreme Court. Yes. Thank you. Good to clarify. So they said, been selected. Okay, wait. Should have been selected. Okay, moreover, after removal of counsel, replacement counsel should have been selected according to the Carroll County Plan from a list of qualified attorneys approved by the county's Public Defender Board, or by referral to the state public defender for selection of replacement counsel. Appointing counsel from Allen County, which is where William Liberato and Robert Scremen were appointed from Allen County. And here they're saying, why did you pick these guys out of Allen County when you're supposed to be following procedure and picking them out of Carroll County? This is so hectic. Everything we've been saying is actually so intense to see it like this. That the courts are now dealing with the same thing of saying, listen, whoa. And I'm so glad that they're stepping in and saying, wait. Something isn't right here. So they said appointing counsel from Allen County, especially the chief public defender of that county, which is William Liberato, deprives Indiana's third largest county of the leader of its public defender office and raises the prospect of loss of reimbursement for Allen County if commission standards are not met. Sure, can you believe it? Janet Klumper says, gee, I hope you are a good swimmer. For this one, you'll have to dive very, very deep. Luckily, I am a good swimmer. I was a competitive swimmer until I was like 20 years old. So yes, that's what I did. Most of my life, 4 hours of swimming a day. So I can swim and we're going to deep dive. Yes. And Barbara Beard said, I'm surprised they don't just yank her off the bench. Barbara Beard also has legal experience. So this is scary. They said argument, okay? So we're on page 5 out of 12 here. This case raises significant concerns about the independence of defense counsel and the public defense structures designed to ensure it. The removal or replacement of appointed counsel must occur in a manner that ensures the independence of defense counsel. IPDC is also concerned that the removal does not undermine the public defender structures in both Carroll and Allen counties. Indiana has been a leader in public defense and the independence of defense counsel. Yeah, 4 pit bulls across America says accountability equals integrity. Yes. Sorry if I'm missing some of your messages there. Okay. So here, let's read this. They said, in many ways, Indiana has been a leader in providing representation to those unable to afford counsel. For example, more than a century before Gideon versus Wainwright, the court held that indigent criminal defendants had a right to counsel provided at public expense. Okay, so here they're going through a whole lot of examples. I put all these documents on Patreon if you are interested. I think they're also out there on X and wherever, but they are on Patreon if you are looking for an easy place just to access them, right? So they're giving a lot of examples. We've got a lot of documents to go through, so I'm just going to go to where I highlighted some bits, which I'm sure was somewhere down here. Wait. There we go. Okay. Here it is unclear why the respondent, that's Judge Gull, appointed counsel in a manner inconsistent with Carroll County's comprehensive plan. Immediately after announcing that Mr. Baldwin had orally moved to withdraw and that Mr. Rosie would be filing a written motion to withdraw, the respondent stated, I will reach out to public defenders to make that appointment. If no qualified Carroll County attorney was able to take this case, the preferred procedure would have been for the respondent court to contact the state public defender for selection of replacement counsel. Not only would this allow reimbursement in what will likely be an especially long and expensive proceeding, but it would also better ensure independence by insulating the selection from control by the judge presiding over the case. I mean, it's just the fight we've seen from the defense attorneys is valid, and the procedures were not followed correctly. So when I've said before, in layman's terms, which I am one, right? I'm not a lawyer. When Judge Gull was kind of stomping around, kind of like, because I said so, this is how it's going to be. You get out of here. We're getting new attorneys. And then it's attorneys that she's also friends with on Facebook. And I don't just mean a friend request that was accepted. I mean interacting with all the photos and saying, oh, they look so fun. I hope you and your kids had a great time. Like, oh dear. Like, you know them. And that's not such a huge deal, maybe, for some. But in a case that's already so fragile, it's had so many twists and turns and so much happening. The poor families, they have been beyond patient. I mean, these murders occurred in 2017, February 13, 2017, the murders of Abby and Libby. Wow. So they said public defense in Allen County is also affected. Instead, the respondent, Judge Gull, reached out to and chose 2 lawyers from Allen County, neither of which is on the Carroll County list, and of whom is currently serving as the chief public defender of Allen County. Thus, in addition to jeopardizing the possibility of reimbursement for Carroll County, the appointment of Mr. Liberato deprives Indiana's 3rd largest county of the leader of its public defender's office and raises the prospect of loss of reimbursement for Allen County if commission standards are not met. Yes, Ronnie for missing persons. P&W says that's such a conflict of interest and completely inappropriate. Barbara Beard says the proper procedure is already clear law. The fact that she didn't follow any of it is also very clear. What they are going to do about it is another story. Yeah, that's true. What is going to happen here? He said, Mr. Allen and the public paying for his defense deserve better. That's what we were saying. The victims deserve better. The families deserve better. And even, yes, the suspect who's innocent until proven guilty deserves better. And here they say Mr. Allen and the public paying for his defense deserve better. As a final point, although this brief focuses on statutes and procedures designed to protect the independence of defense counsel, we should not lose sight of the person most affected. Public defenders do extraordinary, life-changing work every day in courtrooms around the state. Mr. Allen was pleased with the work of his initially appointed public defenders. Mr. Allen and the public that funds his defense should be entitled to more than vague and broad concerns about gross negligence. See, that was vague and broad concerns. It was never clarified because there was never an official hearing. Even that procedure wasn't followed. And then they said, and that a judge cannot and will not allow these attorneys to represent you. I can't do it, sir. I just can't. Why? Because McClellan doesn't want it? I know I always say McClellan when it's McClelland, but I think his surname sounds very Irish, so I say like McClelland. It sounds very Irish to me. McClelland. Such statements do not engender confidence in the criminal justice system for criminal defendants, many of whom believe that appointed counsel is not a real lawyer but a public pretender, or a lawyer who works for the state. When followed, the statutes and decisional law outlined above provide some means to dispel these misconceptions. When not followed, the trust and rapport developed during a full year of intensive representation is lost, and Mr. Allen is left to wait 9 additional months, incarcerated in the Department of Correction under conditions that he and his counsel of choice have stated undermine his ability to prepare his defense. I still think it's crazy that they just chucked him in a prison. I get that they're saying it's for his safety, but the defense has pointed out multiple times that maybe it's not the best option for him. Just put him in a jail where he can be safely in his own cell as well. He can still be segregated. Veronica says, public pretender, lol. Yes, okay, yeah, we go. We've got a lurker coming out to say hi, out of hibernation. Tiffany said, been a lurker for a long time. Best true crime channel on YouTube. Grizzly True Crime always keeps it classy, and he's so protective of the victims and their families. Yes, absolutely. So, conclusion for this document says, the issues presented in this case justify the intervention of this court at this stage to preserve the independence of defense counsel and the integrity of the public defense structures established by the General Assembly. The court can uphold these essential values by reinstating Mr. Allen's initial and desired counsel. Imagine if they get put back on the case. Whoa. In the alternative, the court should direct the respondent court to follow Indiana Code Section 334710B by referring the case to the state public defender for selection of counsel. Wow. Okay, Tracy W. said, it's awful. If we can't have confidence in our system, all procedures must follow the same for all. Yes, I think, that's why there's standards and procedures, and Judge Gull is just kind of doing things her way. Her own way. Okay, so we've done that one. This one is 3 pages. It's a good summary as well. And so they say here, Relator versus Carroll Circuit Court and the Honorable Francis C. Gull, Special Judge. Unopposed motion for extension of time to respond to petition for writs of mandamus and prohibition. The Honorable Francis C. Gull, by counsel, respectfully moves the court for an extension of 5 business days to respond to the relator's petition for writs of mandamus and prohibition. So initially, she had to hand in everything by November 16th. November 9th. Then they made it November 16th. Then she asked for even more of an extension all the way up to November 27th. So we're going to look at that whole procedure now chronologically. Okay. So Joe Quinn said, don't like the attacks on the judge here. Defense counsel royally breached their duties here. Imagine if the prosecution released the crime scene photos. Don't fault for the defense. I think this goes way beyond defense red herrings here. I think this is pretty clear based on the Indiana Board of Public Defenders or Public Counsel and the Supreme Court in Indiana. This is a huge deal what the judge did. I won't argue again about the crime scene photos. I'm not saying 2 wrongs make a right, but those crime scene photos were leaked a long time ago. I showed evidence of that in the last stream. Okay, so I digress. We go on. 1. Respondent is a special judge appointed to the pending Carroll Circuit Court. Also, wait. We're not attacking the judge. We're reading documents, number 1. 2. We all know something stinks in Delphi. Something's up. How disappointing that the judge is now involved in the something's up. That sucks. It should never be this way. This is unnecessary drama at this point. It's terrible. So, and. Okay, I'm going to make one more point. And the judge just hid 125 documents from the public? That's not attacking the judge. That's not correct. She's doing things that are not correct at all. Why hide those documents from the public? Okay. 1. Respondent is a special judge appointed to the pending Carroll Circuit Court matter State versus Richard Allen. The relator's petition was filed on October 30th, 2023 and served by electronic method to the respondent on the same date. On October 30th, 2023, the court issued an order setting a briefing schedule in which all briefs opposing the issuance of a writ must be filed with the clerk of the Supreme Court by November 9th, 2023. That was the original deadline for the judge to respond to that writ of mandamus. The Office of the Indiana Attorney General has declined to represent the respondent in this matter. We saw that. That was the first red flag here. I mean, think about that. The Office of the Indiana Attorney General would normally represent the judge in this case. But they like, no, thank you. Yeah, no, we're going to decline. Okay, causing the respondent to need to engage counsel. On November 2nd of 2023, the respondent asked the undersigned counsel to represent her in this matter. The respondent's engagement of the undersigned counsel was finalized on November 3rd of 2023. If you missed the last live stream of Delphi, go check it out, because there I showed you who her attorney is now. It is Matthew Gutvine. And we went through a few things about that now as well. Okay, on number 6, due to the time required for the respondent to engage counsel to represent her, the respondent's brief in opposition to the relator's petition for writs of mandamus and prohibition is due in 4 business days. The respondent's counsel requires additional time of 5 business days to respond adequately to the issues presented in the relator's prohibition. The respondent respectfully moves that this court grant the respondent an additional 5 business days, up to and including November 16th of 2023, to respond to the petition for writs of mandamus and prohibition. And you know what got added to that now? Transcripts. The defense team has been asking for the transcripts of what happened in those chambers on October 19th. That was before the October 31st hearing. October 19th, okay, when there were cameras in the courtroom, there was chamber meetings before, when the judge is accused of coercing the defense to either withdraw or to be publicly shamed. That's what they said in their documents, right? Now, the thing is, normally there might not be transcripts or a record of what happened in those chambers, but this time the judge kind of shot herself in the foot by including in an email that there were transcripts. So guess what? The defense wants the transcripts. Then they got Richard Allen, temporary counsel, to get those transcripts. Denied. Now the Supreme Court has stepped in of Indiana and saying, okay, we want those transcripts. And the judge doesn't want to give them the transcripts, which that in itself is a red flag. I want to see the transcripts too. Donna says, I want to see those transcripts. This is how we feel now, right, Donna? I want to see them too. Because now it's sounding like, oh dear, what are you trying to hide? Why delay it this much? Now it's all delayed to November 27th. So it was the 9th, then the 16th, now the 27th. All putting the brakes on for like, whoa, but the transcript should just be there. Now we're going to go over more of that now, okay? So this one says, motion for a transcript, State of Indiana, on the relation of Richard Allen, relator, versus the Carroll County Circuit Court and the Honorable Francis C. Gull, Special Judge. Pendizzi says, could she be being threatened? I don't think so. I think maybe the way that she spoke to the defense attorneys in the chambers was a little bit sus, and she doesn't want that coming out now. Maybe, right? Okay, so relator by counsel respectfully requests that this honorable court order that the following transcript be prepared. The in-chambers proceeding held on October 19th of 2023. In support thereof, the relator states the following. The relator has filed this original action after his trial counsel, attorneys Andrew Baldwin and Brad Rosie, were removed from his case due to the court's belief that trial counsel engaged in gross negligence during the representation of Allen. Attorneys Baldwin and Rosie requested the in-chambers proceeding be required, and undersigned counsel confirmed with the court reporter that there is indeed a recording of the proceeding held that day in chambers. So there is a record. Oh dear. So then they say, the Indiana Rules of Procedure for Original Actions require a relator to provide the Supreme Court with a relevant transcript of any evidence in the record if it exists. Attorneys Baldwin and Rosie were disqualified as Allen's attorneys at a hearing on October 31st of 2023. On November 1st of 2023, undersigned counsel contacted Jody Williams, the court reporter, by email to make arrangements for preparation of an expedited transcript. So firstly, Bradley Rosie brought it up of like, okay, let's see the transcripts then. Let's have it. And then already the judge said, nope. And then they got more counsel for Richard Allen. Nope. Then the Supreme Court stepped in and said, we want the transcripts. And the judge said, nope. She said, no, sorry, that's confidential. And the Supreme Court, excuse me, you are going to give those transcripts. So that's what's happening. Laurie, thank you for your sticker. You say, is the legal system here in the US the same as SA in the Netherlands? Not really. Same, but different. That's a long answer. That's the shortest I can give right now. Sort of, but not really. Also very different. So they say you guys are a lot more transparent, I think. I mean, just the ability to see documents and trials. I mean, we see some trials in South Africa, but not all. In the Netherlands, no. You know, just like the cameras, the body cams, the everything. It's very different. Okay, so here they say, court reporter Williams was out of office that day, but promptly responded to the client's email the next morning on November 2nd, 2023. Court reporter Williams informed counsel that the hearings held in open court on October 19th of 2023 and October 31st, 2023 could be prepared and made available by November 3rd. See, then again, they said, yes, we have it, but it can be made available on November 3rd. However, with respect to the in-chambers proceeding, the court reporter Williams informed counsel that the in-camera meeting was a meeting of the parties and not a hearing in open court. It's confidential, and I'm unable to provide that at this time. Undersigned counsel, Cara Vanica, responded that she would prepare and file her limited appearance and written motion for transcripts as limited appearance counsel in the cause on behalf of Allen. Counsel informed the court reporter that Attorney Vanica should be permitted to receive the transcript regardless of its confidential status. After acknowledging that Attorney Vanica's limited appearance and motion for transcript were on the docket, court reporter Williams informed counsel that she still maintained the in-chambers proceeding was confidential and thus she could not provide a transcript to counsel until the trial court granted the motion for transcript. On the morning of November 3rd, 2023, undersigned counsel Mark Lehman actually got in his car, traveled to Fort Wayne to obtain the transcript of the hearings held in open court. Before Attorney Lehman left Fort Wayne, Attorney Vanica asked court reporter Williams if Attorney Lehman should remain in Fort Wayne in the event the trial court ruled on the motion for transcript. In response, court reporter Williams indicated the counsel could not obtain the transcript that day, even if the court permitted them to have it. Oh dear. So, as of the date of this filing this motion, the trial court has not ruled on counsel's motion for transcript. Due to the emergent nature of this original action, counsel filed the record of proceedings without the transcript of the in-chambers proceeding and now asks this court to order the transcript to be prepared. Now, I have actually seen transcripts from the October 31st hearing, so it's really suspicious that they will not provide the transcripts from what happened in the chambers and in the courtroom from October 19th. Sarah Gilliot, welcome to Grizzly Supporter. All right, and so they say, as of this date, the trial court has not ruled on the counsel's motion for transcript due to the emergent nature of this original action. Counsel filed the record of proceedings without the transcript of the in-chambers proceeding, and now asks this court to order the transcript be prepared. Wherefore, related by counsel, respectfully request that this honorable court order that the in-chambers proceeding held on October 19th, 2023 be transcribed. Yeah, another red flag. Donna says, Grizzlies, we have a busy day. Visine trial next. Yay! Yes. So, now, here's one for another motion for extension of time. I just want to see if this is the right one. Yeah. Okay. So here, it says State of Indiana, Richard Allen, relator, versus the Carroll Circuit Court and the Honorable Francis C. Gull, Special Judge. Motion for extension of time, again, to respond to the petition for writ of mandamus and a motion for transcript. Okay? So then, the Honorable Francis C. Gull by counsel respectfully moves the court for an extension of 5 business days to respond to the relator's petition for writ of mandamus and to respond to the relator's motion for transcript. In support of this motion, the respondent states, the respondent is a special judge appointed to the pending Carroll Circuit Court matter, State versus Richard Allen. The relator's petition was filed on November 6th of 2023 and served through electronic means the same date. On November 6th, 2023, the court issued an order setting a briefing schedule in which all briefs opposing the issuance of a writ must be filed with the clerk of the Supreme Court by November 16th of 2023. So that's what we last discussed. That's what we were kind of waiting for, like what would happen after that. This is the same date that the respondent's brief opposing petition is due in an original action involving the same parties, State Richard Allen versus Carroll Circuit Court. The Office of the Indiana Attorney General has declined to represent the respondent in this matter, causing the respondent to need to engage counsel. Later in the day, November 8th, the respondent engaged the undersigned counsel to represent her in this matter. On November 8th of 2023, the court issued an order for respondents to respond to the relator's motion for a transcript or to submit the transcript as a supplemental record. The deadline to complete this action is November 16th of 2023. On November 8th, the Indiana Public Defender Counsel tendered an amicus brief in support of the relator's petition for writ. Due to the time required for the respondent to engage counsel to represent her, the complexity of the matter, the requirement to respond to the court's order on the relator's motion for the transcript, and the addition of arguments set forth in the amicus Indiana Public Defenders Counsel's brief, the respondent, Judge Gull, requires additional time to submit a brief opposing the relator's petition and to comply with the court's order on the relator's motion for a transcript. 9. Okay, the responders, so Judge Gull's counsel requires additional time, more time, of 5 business days up to and including November 27th of 2023 to file a brief opposing petition and response to the motion. See, they say and a response to the motion for a transcript. I wonder what that response will be. Are they still going to refuse to hand over the transcripts? That is so suspicious. I hope it doesn't get lost along the way, but I have a feeling it might. I hope not, because that would not be correct. 10. Respondent respectfully moves that this court grant the respondent an additional 5 business days up to including November 27th, 2023 to file a brief opposing the petition for writ of mandamus and response to the relator's motion for transcript. The respondent's counsel has confirmed with the relator's counsel concerning this request. The relator's counsel has informed the respondent's counsel that he does not consent to this request. Wow. And then look at this one. I just want to show you this last one here. Let me just put it here. This is a better order of it. Here, look at this order here, okay? Ooh. I just want to see something quickly. Sorry, I'm missing lots of messages. Just hold on. Yes, so Barbara said, knowledge of what occurred during an in-camera hearing can affect the outcome of a trial. That's why they're in camera, at least until the issues are decided. However, they are not seeking evidentiary information, but improper conduct in removing the attorneys for the defendant. Absolutely, yes. Yes, Barbara. Also, Raptorman, none of these arguments are about whether Richard Allen is bridge guy or not. It's about Richard Allen having a fair trial. Whether he's bridge guy or not, whether he committed the murders or not, he's going to be on trial. He deserves a fair trial. This is all about the defense attorneys, the judge, how the judge handled that, their withdrawals and things like that. Okay, look at this order. I already highlighted the points there for you. So this actually just goes over everything we just went over. So let's go to the highlighted portion where it says, this is the Indiana Supreme Court. Being duly advised, the court grants the respondent's motion for extension of time to respond to petition for writ of mandamus and motion for transcript. The respondent's response brief and any supplemental records must be filed directly with the clerk of the Supreme Court on or before Monday, November 27th of 2023. And there they say no further request for extension will be granted, meaning this is it. No more putting on the brakes. No more extending the deadlines. This is it. November 27th, Judge Gull has to respond to those motions. The reader, welcome. Okay. Yes, Hudson Lawrence says, what if he's bridge guy but BG didn't do it? I mean, there's a lot that we could talk about here. Today we're focusing on Judge Gull's conduct, which has been by all, if we look at all these documents, not according to procedure, and obviously not also allowing Richard Allen to have the right to his defense counsel, the right to a fair trial. It's sounding like quite impartial and all of that. Okay, so we're looking at that. Yeah, Stefan says, that sounds like no chit-chat anymore, Gull, do your job. Yeah, it's kind of like, we're not friends, okay? You're just going to do this. This is your deadline. We want to see it by then. And I really wonder if those transcripts will be produced. And if so, what the hell happened in those chambers, right? Okay, so. Yes, Sarah. Sarah, the stream will lead you to that one. We're doing it right after this. In the next 20 minutes, we'll be live over there for the next day of the trial. Okay. And then there's this final one, which said relators. Wait, this was filed. Look at that. Wait, that's what I wanted to show you. I just want to go to the top here. To the top. Can you see the top there? I have to make it a little bit bigger for you. This was the motion for extension of time, and that was sent at 9:21 a.m. And then the relator's objection to the respondent's motion for extension of time was at 10 a.m. on the same day. It's like within 39 minutes, they're like, no, okay. So, relator Richard Allen by counsel, Cara Schaefer Weinicke and Mark Lehman respectfully object to the respondent's request for an extension of time within which to file their responses. The relator states the following. Since November 2022, the relator has been confined in a maximum security segregation unit in the Department of Corrections, where he has been subjected to conditions that have led to him losing nearly half his body weight and at times experiencing symptoms of psychosis. On several occasions, his trial attorneys requested his move to a better facility, like the Cass County Jail. Why can't they just put him in there? Yeah, Stefan says, oh my word, they are quick. They are, right? Steve says, finding BG's true height is elementary. Okay, and so they said, yes, like I'm saying, like the Cass County Jail, right? On one of those occasions, Attorney Rosie himself arranged for the relator's move to the Cass County Jail, where the Cass County Sheriff agreed to accept the relator. Yet these repeated requests were denied. Every day that relator spends in those conditions has a deleterious effect on the relator. That would be Richard Allen. Moreover, Richard Allen was set to proceed to trial in January of 2024 with a well-developed trial strategy and proffered defense. Yet, due to the actions of the respondents, that means Judge Gull, okay, that trial date has been continued for at least 9 months. The relator is in a state of limbo and cannot move forward until this action is resolved. Undersigned counsel were retained to initiate this original action on November 1st of 2023. Despite their heavy caseloads, counsel were able to file this action only 5 days later. Respondents currently have 7 days from the filing of this objection to respond. During counsel's preparation time, they were denied by respondents the ability to obtain one of the transcripts relevant to this action or even to listen to the audio recording from that proceeding. Oh dear. For the other transcripts, the court reporter for the respondent refused to accept undersigned counsel's promise of payment by mail, even though they are officers of the court. The court reporter also refused to email electronic copies of the transcripts to counsel. This required counsel to physically drive to Allen County and back to obtain the transcripts. Finally, the respondents were aware the relator was filing this action no later than November 2nd of 2023, when the court reporter contacted undersigned counsel about the request for an expedited transcript. On November 3rd of 2023 at 9 a.m., Deputy Attorney General Angela Sanchez contacted Attorney Weinicke and asked how soon the relator would be filing the next original action, so that the Attorney General could make arrangements. Attorney Weinicke immediately responded that the relator would be filing on Monday morning, that there would be an emergency writ request, and that we had an organization that would be filing an amicus brief. When the original action was filed on the morning of November 6th, the relator sent a copy of all pleadings to the Respondents' Counsel, Attorney Goodfine. That's Judge Gull's attorney. Wherefore the relator, by counsel, respectfully objects to the respondent's request for an extension of time. And that's why, as we saw, the Indiana Supreme Court said, okay, you can have that extension, but November 27th, 2023 is it. Wow. So we made it through all those documents. Now I can actually see what you guys are saying. Let's see. Ina says, who leaked the PCA? I don't know if did anyone leak the PCA? I'm trying to remember. I remember it was sealed, and then the judge was the one to authorize it being unsealed. But it was redacted, and later there was another version released by the court that was unredacted. So that's also something to consider. A lot of times when, like the memorandum for Frank's motion, when everybody's all up in arms, what about all these families that they've mentioned now, all these, odorness and all of this? Why would they just put their names out there? Well, that's up to the court as well to redact it. The attorneys can't redact it because it has to go into official record. The court has to redact it. And throughout this case, there's been many documents that were released that really should have been redacted, including some of the latest ones, which I myself, in the last stream, if you remember, I had to redact. Otherwise, we'd all have McClelland's number now. Like, okay, let's just give him a call there. Yeah, I don't think no one leaked the probable cause affidavit. That was released by Judge Fran Gull. And actually, we gave her a lot of, kudos back then, because we're like, okay, because it was actually the state that wanted it, the prosecution that wanted to keep that probable cause affidavit sealed. And what was their reason? Do you remember? Their reason was that they want to keep it sealed because there may be others involved. They're still investigating, and there might be other arrests. And I'm like, whoa, that was a big statement. So then Judge Gull actually said she needs some time to think about it, consider all the factors, and later she said she's releasing the probable cause affidavit, but a redacted one, with the witnesses' names redacted. So there was that. And then at some point, the Ron Logan search warrant, that was unsealed via a motion, which I think was by podcasters. So that was interesting to read as well. Oh, so many things along the way. Okay. Marie, thank you so much for your message. You say, hi Gisela, baie dankie vir al die inligting. Ons waardeer jou tyd, moeite en mees belangrik en ooglopend met hoe jy alles benader, jou hart. Thank you so much. Should I translate a little bit? So it's like, thank you so much for all the insight, time and effort and everything, and that my heart is in it. Thank you. Really appreciate it. Wow. There's actually so many documents that I could go over, but I don't want to make it too much, because I'm also just like bit by bit and chunk by chunk looking at all these documents. I just wanted to bring this to you today. I've actually wanted to for the last few days. I've just been like so busy with this trial that we will be looking at day 13 right after this stream, that I didn't have time. But I'm so glad I could see you today. And I know many of you are off today as well. So it's really nice that we could go through this, because this is really serious. I mean, it's always been very serious. It's a very fragile case with lots of strange events, consequences, coincidences. I mean, now consequences, yeah. Coincidences which became consequences, and now it's just so unfortunate that the judge is being looked at by the Indiana Supreme Court and the board and everything. That should never happen. Of all people, one should be able to trust the judge, So I think it sucks. It makes me really sad for Abby and Libby and for their families. I mean, they've been waiting for 6 years for justice, and it's like hanging in there for January 8th when the trial was supposed to start. Now it's not going to. So far, the defense in the last stream we did actually again filed. They're still fighting for Richard Allen, said, we're ready to go. We're ready to go to trial within 70 days. Let's do it. So if they get reappointed after all of this, wow, maybe the trial will happen in January. We shall see. For now, it's been set for October 15th to November 1st, I think it was. Yes. Steel Guitar says Gull doesn't consider herself above the law. She thinks she is the law. Imagine having a judge like we've just seen in Jesse Kershevsky's trial, Judge Dorrow. Oh man, imagine having Judge Dorrow on this case. Wouldn't that just, it's just such a high standard. That feels like we can trust that, right? As the public, we can trust that. I mean, trust has been broken quite a lot in Delphi, and especially now with the judge's conduct. So it's not about attacking the judge. It's about wanting fairness, no corruption, truth. And even like that, the transcripts, that's truth. It's words that were said in the chambers. The judge herself said they've got a record of it. The clerk said they've got a record of it, but they won't hand it over. That's not nice. How are you supposed to trust that? Okay. Kerry says, in my opinion, Judge Gull thinks that she's the judge, juror, and executioner, and God. That's a lot. But yeah. Now we shall see what happens next. I don't know what's going to happen next. I don't even know what to think. It's kind of anxiety inducing, isn't it? Like, oh no, what's going to happen now? Is this judge going to have to recuse herself? I still wonder why exactly Judge Benjamin Diener recused himself. Shortly after Richard Allen was arrested, actually on the day when he signed that form to have him transported to where he's been housed ever since. The Westville Correctional Facility, which is a prison, not a jail. Richard Allen is innocent till proven guilty. And they really have, from everything we've seen, circumstantial evidence. It's a pretty flimsy case, which is also, I think that was part of why they wanted the probable cause affidavit sealed. They're like, no, there could be others, and we just want to protect that. And we want to protect the juvenile witnesses. I understand that. But it's more like, oh crap, we have a flimsy case. You know? So, yes, Papa says public record, not private. And it's shocking to think how many documents were made private for no reason in this case. 125 documents were hidden from the public, which they shouldn't have been in this case. That's scary. So, Teresa says previous judge threatened? I wonder. I wish we could interview the previous judge. I'm sure he won't talk. But Judge Diener, what does he have to say now? And also, remember the former prosecutor, Robert Ives? I mean, he ended his term early. He's like, oh, okay, yeah, I'm out. Like shortly after the murders occurred. And when the investigation was in its early stages, Nicholas McClellan took over. Yes, there's so much we could discuss. I have a lot going on here now. I'm just thinking of all these things. Delphi is a massive case. Oh my goodness. Since before I was even here on YouTube, I joined YouTube. I made my channel at the end of June of 2021. Before that, right, when I was lurking in the chats, watching true crime, right, and listening to podcasts, Delphi was already so huge. The case was already, there was a lot of red flags. You know, something didn't seem quite right back then. Since it happened in 2017, I can't believe where the case is now. So let's continue to remember why we're looking at all these documents, why we cover the case. We want justice for Libby and Abby. How do we get that? Richard Allen, the suspect, needs a fair trial. If he's not the guy, whether he is or isn't, or if there's more people to be arrested, let's hope that more people will be arrested. If he isn't the person, arrest the right person, whatever it may be. If he is, and it's a lone wolf situation, which they've never said, law enforcement, the prosecutor, they've never said this is one person or one person only. All their sketches and all their theories and everything that they put out there. Remember, Doug Carter said, it's not about what we think, it's about what we know. Well, what they said they know sounded an awful lot like there's more people involved. So where is that information? You know? Even if they're no longer with us. We shall see. Okay, so thank you so much, everyone, for being here. We got to get ready for that next live now. I'll be reading the live chat replay afterwards. I hope that you are now up to speed with at least the latest documents in this Delphi case. Whenever there's more documents or more news or anything, of course, I will keep you posted. So if you are following me for Delphi coverage, because some people follow only for certain cases, then make sure you're subscribed. Hit it again, set your notifications to all, then you'll see when I upload or go live about Delphi again. Check out the playlist if you haven't yet. And now we'll be teleporting ourselves to the next stream where I'm going to be covering day 13 of the Jesse Kershevsky trial, and it's really gonna be a snarky one. A lot of snark, a lot of roasting. Very interesting, and the defense rests. So we'll do that, okay? Thank you, mods. Really appreciate it. Thank you, everyone, for being here. I'll see you over there. I hope it works out that you get teleported there now. Here we go. After the outro, you should go there automatically, but I'll also put the link in the chat for you. Okay, bye, everyone.